Right now, if you were to die tonight, a court could take control of everything you have spent a lifetime building, your IRA, your bank accounts, your home, and hand it to people you never intended to receive it. Not because you did anything wrong, because you never signed three specific documents. And in some cases, that oversight costs families tens of thousands of dollars before they ever see a single penny of what their loved one left behind. Today, I am going to show you exactly what those three documents are, why the system is designed in a way that profits from you not having them, and what you can do this week to make sure a judge you have never met does not become the most important financial decision maker in your family. Let me start with something most people do not understand until they are inside it. Probate. A word everyone has heard, a process almost nobody fully grasps until it is too late to avoid it. Here is the plain English version. When you die, if your assets do not have a mechanism to transfer automatically, a beneficiary designation, a trust, a joint ownership, or a payable on death registration, those assets go to probate court. The court then oversees the legal process of paying your debts and distributing what is left to your heirs. Sounds orderly. It is not. Probate in many jurisdictions routinely takes a year or more to fully resolve. During that time, your family may not have access to those funds. They cannot pay off your mortgage from your savings account. They cannot settle medical bills. They cannot do anything without the court's approval. And while the court is taking its time, the bills keep coming. On top of the delay, probate costs money. Legal fees, court costs, executor commissions. In a middle-class estate, these expenses can easily consume tens of thousands of dollars. Money that was supposed to go to your children or your spouse goes instead to the court process itself. That is money you earned, gone. Not because of bad investments or bad luck, because of a missing signature on a document that would have cost you a fraction of that amount to prepare. Now here is something even more important, and this is where I see families blindsided most often. A will does not automatically keep you out of probate. Many people believe that having a will means everything is handled. It is not. A will is simply a set of instructions that the probate court follows. You still go through the court process. You still pay the fees. You still wait. What actually keeps assets out of probate are specific legal tools: beneficiary designations, payable on death and transfer on death registrations, joint ownership, and living trusts. These mechanisms transfer assets directly to the people you choose, outside of the court system entirely. A single transfer on death designation on a brokerage account can redirect hundreds of thousands of dollars straight to your heirs without a judge ever getting involved. And if you die without a will at all, without any estate planning documents, the state steps in with what are called intestacy laws. These are the state's default rules for who inherits your estate. They do not know your family, they do not know that you are estranged from a sibling, or that you have a grandchild you wanted to provide for, or that your second spouse has no legal claim under the old rules. The state applies a formula. That formula may send your life savings somewhere you never intended. So let me walk you through the three documents that can change all of this, not in vague terms, in plain English with specific explanations of what each one does and what happens to your money if you do not have it. The first document is a will. I know, you have heard this before, but hear me out, because most people who think they have this covered actually do not. A substantial share of American adults have no will at all, and of those who do, many are relying on paperwork they signed 20 or 30 years ago, before a divorce, before a remarriage, before grandchildren were born, before major assets were accumulated. That outdated will can do real damage. Consider what happens when a widowed parent remarries and never updates their estate documents. The old will may direct assets to a deceased spouse or to children from a prior marriage in proportions that no longer reflect the family's reality. And here is something most people do not realize. If your will names a beneficiary who has already died and you never updated the document, some states will treat that share as if it falls into the general estate, meaning it goes through probate and gets distributed under the state's default rules, not yours. There is also the issue of beneficiary designations. This is critically important. Your IRA, your 401k, your life insurance policy, and most brokerage accounts transfer by contract law through beneficiary designations, not through your will. Whatever your will says does not matter for those accounts. The beneficiary form controls. If you named your ex-spouse on your IRA 20 years ago and never changed it, your ex-spouse collects that money. The court must follow the old paperwork. Your children have no legal recourse. This exact scenario plays out in courtrooms across this country every single year. Three siblings discover that their mother's $350,000 IRA, the centerpiece of her estate, is going to an ex-spouse because the beneficiary form was never updated after the divorce. The will says one thing, the contract says another. The contract wins. Every time. Reviewing and updating your beneficiary designations costs you nothing but time. One change, one updated form submitted to your IRA custodian can redirect hundreds of thousands of dollars directly to the people you actually want to receive it, bypassing probate entirely. That is one of the most powerful financial moves available to any retiree, and the industry has very little incentive to remind you to do it. The second document is a durable financial power of attorney. Let me explain what durable means because the word matters legally. A standard power of attorney becomes invalid the moment you become incapacitated, precisely the moment you most need someone acting on your behalf. A durable power of attorney is specifically written to remain effective after incapacity. That distinction can mean everything. Here's what happens without one. A retired teacher suffers a stroke. She is alive, but she cannot communicate, cannot sign documents, cannot authorize transactions. Her mortgage is due. Her medical bills are coming in. Her adult children need access to her accounts to keep her financial life from unraveling while she recovers. Without a durable power of attorney in place, those children cannot touch her accounts. Not legally. They must go to court and petition for guardianship or conservatorship, a formal legal process in which a judge determines that their mother is incapacitated and grants one of them the legal authority to manage her finances. That process takes time. It costs money. Families in emergency situations often face immediate legal fees of several $1,000s just to get started before a single bill gets paid. And once guardianship is established, the court does not simply hand over control and walk away. In many states, guardianship involves ongoing court oversight, annual accountings, and fees for court-appointed monitors or professional guardians, costs that can run into thousands of dollars per year, drawn directly from the person's savings. A $500,000 nest egg can erode steadily through this process, while the family feels completely powerless to stop it. A durable financial power of attorney, drafted properly and signed while you are still healthy and competent, prevents all of that. It names a person you trust, a spouse, an adult child, a close friend, and gives them the legal authority to manage your finances immediately if you become unable to do so yourself. No court, no delay, no ongoing fees paid to a stranger appointed by a judge. Now, I want to say something important here because this document can also be misused. Elder financial exploitation frequently involves the misuse of a power of attorney. A caregiving relative, a new acquaintance, even a professional, if they are named as your agent and they act in their own interest rather than yours, the damage can be catastrophic. Many states specifically criminalize financial exploitation through misuse of a power of attorney. Federal and state elder financial exploitation statutes make it illegal to take, misuse, or withhold an older adult's money without informed consent. But the legal protection only works if the document is drafted carefully, if the agent is chosen wisely, and if trusted family members know the document exists and can monitor how it is being used. A power of attorney drafted poorly or handed to the wrong person is not a protection. It is a vulnerability. That is why the drafting matters as much as the signing. The third document, and this is the one people most often skip, is either a living trust or a comprehensive advance directive package that includes a healthcare power of attorney. These serve different but equally critical functions, and for many middle-class retirees, both are worth having. A living trust, sometimes called a revocable living trust, allows you to transfer ownership of your assets into the trust during your lifetime. You remain in control as the trustee. You can add or remove assets, change beneficiaries, and amend the trust at any time while you are competent. But when you die or become incapacitated, the trust continues operating without court involvement. Your chosen successor trustee steps in immediately, manages the assets according to your instructions, and distributes them to your beneficiaries when the time comes, all without a probate judge, without public court filings, and without the delays and fees that probate brings. For a retiree with $100,000 to $800,000 in assets spread across IRAs, brokerage accounts, and home equity, a living trust is one of the most direct ways to keep a court out of your financial life. And unlike probate, which is a public process, meaning anyone can look up what you owned and who received it, a trust is private. Your family's financial situation stays between your family. The healthcare power of attorney and advance directive complete the picture. These documents designate someone you trust to make medical decisions on your behalf when you cannot make them yourself. This is not just about end-of-life care, it is about every medical decision that carries a financial consequence, and in retirement, almost all of them do. Long-term care and nursing home stays can cost $80,000 to $120,000 per year or more. Who controls how your savings are spent on that care matters enormously. Without a healthcare power of attorney, those decisions may fall to whoever the hospital staff can reach, or ultimately to a court-appointed guardian who does not know you, does not know your values, and is not accountable to your family in any meaningful way. The advance directive tells medical providers what kind of care you want. The healthcare power of attorney names the person who enforces that. Together, they ensure that a trusted individual, not a courtroom process, controls decisions that can cost or protect hundreds of thousands of dollars. One more thing worth knowing. If you are considering a continuing care retirement community, or if you already live in one, the 3 documents we just covered matter even more than you might think. At least 14 of these communities have filed for bankruptcy since 2020. Residents who handed over entrance fees of $100,000 to over $1 million discovered that under bankruptcy law, Wall Street bondholders get paid before they do. Their life savings came last. And those who had no power of attorney, no trust, and no agent authorized to fight on their behalf were the most exposed. The estate plan is not just about what happens when you die. It is about what happens when the institution you trusted fails first. Before I close, I need to tell you about a threat that sits at the intersection of everything we have covered today: court authority, powers of attorney, and the fear that your savings are in danger. Because bad actors have studied the same system I just described to you, and they have built an entire criminal industry around exploiting your uncertainty about it. Here is how it works. You receive a call, an email, or sometimes a letter that looks official. Someone tells you that a judge has issued an order involving your accounts, that your money is at risk, that government agents have identified suspicious activity, and you must move your funds immediately to a protected account to comply with the court's directive. The caller is calm, professional. They use legal-sounding language. They know your name. This is a well-rehearsed script designed to make you move money before you have time to think clearly. And it works. Older adults lose billions of dollars every year to financial exploitation and scams, and a significant portion of those losses happen in a single transaction. One wire transfer, one cashier's check, one move of an entire account balance before anyone in the victim's family even knows it happened. One documented case involved a veteran who was convinced that a judge had ordered him to transfer $250,000 to a so-called safe account. He complied. There was never any court order. That money was gone before he reached the end of the phone call. And the reason scams like this succeed is precisely because the victims do not know what real court authority looks like. They have never seen a legitimate court order. They have no estate plan in place, no trusted agent already authorized to review unusual financial requests, and no system to slow things down before money moves. That is exactly where a properly drafted, durable power of attorney with a trusted adult child or advisor copied on major account activity creates a practical layer of protection. When your agent already has authority and your family already knows your financial picture, it is much harder for a stranger to insert themselves into a crisis that does not exist. The document is not just protection from incapacity, it is protection from predators who manufacture the appearance of incapacity and emergency. I want to be direct with you now, because everything I have described in this video leads to one practical conclusion. The 3 documents I have walked you through, a current will with updated beneficiary designations, a durable financial power of attorney, and a living trust or advance directive package, are not complicated to obtain. A well-drafted basic estate plan for a typical retiree commonly costs in the low 4 figures. That is a one-time expense that can protect a 6- or 7-figure estate from avoidable court costs, delays, exploitation, and family conflict. Compare that to what the alternative costs. Probate fees and legal expenses that can easily consume tens of thousands of dollars from a middle-class estate. Emergency guardianship proceedings that can run several $1,000s before a single bill gets paid. Ongoing court oversight fees drawn annually from a nest egg that was supposed to last your lifetime. Or a single scam call that drains a $250,000 account in minutes. The math is not close. Here is what I want you to do this week. First, pull out whatever estate documents you currently have. Your will, any powers of attorney, your advance directive if you have one. Look at the date. If those documents are more than 5 years old, or if anything significant has changed in your life since they were signed, a marriage, a divorce, a death in the family, a move to a different state, a major change in your assets, treat them as if they do not exist until a qualified estate planning attorney in your current state has reviewed them. Estate planning law varies by state, and a document that was valid in one state may not carry full legal force in another. Second, contact every financial institution where you hold an IRA, a 401k, a brokerage account, or a life insurance policy and ask them to send you the current beneficiary designation on file. Do not assume you know what it says. Request the actual form. Review it. If it is blank, outdated, or names someone who is no longer the right person, update it immediately. That single action costs you nothing but time and can redirect hundreds of thousands of dollars to exactly where you want it to go. Third, if you do not have a durable financial power of attorney and a healthcare power of attorney currently in force, make an appointment with an estate planning attorney this week. Not next month, this week. Incapacity does not announce itself in advance. A stroke, a fall, a sudden cognitive decline, these events do not wait for a convenient moment. The document only works if it is signed before you need it. And if you are considering a continuing care retirement community, or if you already live in one, ask your attorney to review the entrance fee contract structure specifically. Who holds the refundable deposit, how it is secured, and where you stand as a creditor if the facility ever faces financial distress. The pattern of bankruptcies since 2020 is not an anomaly. It is a structural risk built into how many of these communities are financed, and deposits representing 50 to 80% of a retiree's liquid net worth deserve the same scrutiny you would give any major investment. The system I have described throughout this video is not going to change in your favor on its own. Probate courts will keep collecting fees. Bankruptcy law will keep putting bondholders ahead of residents. Scammers will keep calling. But none of that has to touch your savings if you take the steps available to you right now, while you still have the capacity and the time to act on your own terms. That is exactly why I put this channel together. If that is the kind of information you want delivered every single day, subscribe right now and hit the bell so you do not miss anything.